Hello, everyone, and welcome to another edition of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 10 of the Forge of Freedom. Before we get into the topic for today, I just want to tell you a little bit about the podcast. I'm an attorney, a firearms instructor, and a husband with a passion for freedom. At the Forge of Freedom, we believe that freedom is the highest political goal, and we believe that individuals thrive where freedom and personal responsibility coexist. Without a populace that shares a passion for freedom and personal responsibility, the world can quickly devolve into tyranny. And it is our hope that this podcast can help motivate our listeners and those around them to create and preserve freedom for themselves and for future generations. But the task of creating and preserving freedom is not an easy one. Freedom is not given to us by government, and it is not passed on in the bloodstream. Freedom is forged through personal responsibility and continued vigilance. We want to motivate you and equip you with the knowledge, the skills, and the attitude to develop your body, mind, and soul for the task of living a freer life and creating a freer world. We want you to have the body of an athlete, the mind of a stoic, and the spirit of a warrior. We want you to be the Forge of Freedom. With that said, once again, I'm your host, Alex Ooley, and this is episode 10 of the Forge of Freedom. So let's go ahead and jump into the topic for today. What is jury nullification? In a strict sense, jury nullification occurs when a jury returns a not guilty verdict, even though jurors believe beyond a reasonable doubt that the defendant has broken the law. Because the not guilty verdict cannot be overturned, and because the jurors cannot be punished for their verdict, the law is said to be nullified in that particular case. In what can be said to be a milder form of jury nullification, some of the jurors, or even just one in most cases, can hang the jury by maintaining a not guilty verdict, even though they believe the defendant broke the law. There is no requirement that jurors must come to a unanimous verdict. If the jury cannot unanimously agree on a verdict of either guilty or not guilty, this is known as a hung jury. When further deliberation among the jury clearly will not be productive, the judge will declare a mistrial. The prosecution may or may not retry the case in the future, but the law has at least been nullified in the trial at hand. There's a story about a former prosecutor and current Georgetown University Law Center professor, Paul Butler, has dubbed another variation on this theme to be jury nullification 2.0. He used the term in reference to a case of Teray Cornell, a Missoula, Montana man charged with possession of 1/16 of an ounce of marijuana in a county that had passed a citizen initiative instructing law enforcement to make marijuana enforcement their lowest priority. Of 27 potential jurors questioned during jury selection, only 5 said they would vote to convict a person of possession of such a small amount of marijuana. Skeptical that it would even be possible to seat a jury, the judge in the case called a recess, during which time the lawyers worked out a deal known as an offered plea, where the defendant doesn't actually admit guilt. Offered pleas are only available in certain jurisdictions. Indiana is not one of those. But I tell the story because these kinds of rejections of enforcement of the law stack up over time, and it can be to the point where the law, in particular instances, becomes unenforceable. We've seen this sort of rejection of the fugitive slave laws and alcohol prohibition, for example, where the sentiment of the jury or the jury pool undermines the enforcement of such laws. Eventually, it is no longer even worth the time or the hassle or the embarrassment for government officials to try to enforce these laws. They may be further nullified, in a sense, either remaining on the books but not being enforced or being repealed altogether. Sometimes jury nullification is sometimes called conscientious acquittal, juror veto, or jury pardon. So why are we even talking about jury nullification? Well, jury nullification is a powerful mechanism built into our system of justice and can act as a buffer between individuals charged with a crime and unjust or overly harsh laws. And we're talking about it because it's a concept that many people are not aware of. Many potential jurors are not aware of. John Jay, the first Chief Justice of the United States Supreme Court, had this to say. He said, "The jury has the right to judge both the law and the fact in controversy." This sentiment does not reflect some quaint or offbeat ideology or radical ideology, but rather the consensus of opinion at the founding of our nation. Our founding fathers understood that the constitutional republic they had crafted was a fragile thing. And without proper safeguards, it could fall prey to tyranny disguised as law. They recognized that one of the most essential safeguards was the power vested in the common citizen through the jury box. And that right to a jury trial was recognized in the Bill of Rights. If our nation's founders were able to come back today and witness the instructions that judges give to juries, they would react with horror at the emasculation of our once proud jury system. Generally, the juror in a criminal case is instructed to accept the letter of the law without question and apply no moral judgment to their decision. To the nation's founders, today's jury system would appear as nothing more than a ghost of its former self. In Indiana, for instance, case law says that a jury may have the power to disregard the instructions, but not the right to do so. And the trial court is not required to instruct the jury concerning this power. So what this is saying is that the jury has this power to decide the law and the facts and to nullify the law in certain cases, but the judge should not instruct them as to this power. The judge should not inform the jury that they have this power. In fact, a jury has the power to ignore or disregard the law completely to the extent that a jury may return a verdict of not guilty, and the verdict is not subject to reversal because of the prohibition against double jeopardy. Nevertheless, a defendant in Indiana, according to the courts of this state, does not have the right to have the jury instructed concerning this power. So essentially, what the courts in Indiana have said is that jurors have this power of jury nullification, but let's not tell them about it. So that's why I'm telling you about it. The founding generation would wonder how we managed to stray so far from the original pattern they instituted, and why, as a result, America has chosen to place her freedoms in such obvious peril. Our forefathers understood far better than we that for a nation to remain free, sovereign power must rest in the people themselves. And I want to point out just a few quotes to illustrate this point. John Adams and Thomas Jefferson were very strong advocates of jury nullification. They said, "It is not only the juror's right, but his duty to find the verdict according to his own best understanding, judgment, and conscience, though in direct opposition to the direction of the court." John Adams goes on to say, "It would be an absurdity for jurors to be required to accept the judge's view of the law against their own opinion, judgment, and conscience." Thomas Jefferson, in a letter to Thomas Paine in 1789, says, "I consider trial by jury as the only anchor yet devised by man, by which a government can be held to the principles of its Constitution." And then Thomas Jefferson, once again, in a letter to Samuel Kercheval, says, "The juries are our judges of all fact and of law when they choose it." Even the first Chief Justice, whom I mentioned earlier, John Jay, in 1789 chimed in on this issue with, "The jury has the right to judge both the law as well as the fact in controversy." And then lastly, and most succinctly, Alexander Hamilton in 1804 says, "Jurors should acquit even against the judge's instruction, if exercising their judgment with discretion and honesty, they have a clear conviction the charge of the court is wrong." The Founding Fathers designed the jury system to act as a constant check on the excesses of government and the abuses of unjust law. Individual jurors acknowledged that they had not only the authority, but the moral responsibility to acquit just men who ran afoul of unjust law. Throughout the history of our republic, there have been many instances of juries that stood firmly for justice in the face of illegitimate law. They commonly refused, for example, to enforce the British Navigation Acts against the colonists, and later the Fugitive Slave Act against the abolitionists. American history would have been written much differently if the juries of the past functioned like the juries of the present. Sadly, a modern-day jury would just toss those abolitionists in jail, not because we now believe in slavery, but because juries today are consistently misinformed from the bench about their essential role in securing justice and are thus rendered powerless in the defense of freedom. They are instructed to determine the facts, apply the law, and go home. Judges, prosecutors, and lawmakers are afraid of a fully informed jury. Confusion over whether or not jury nullification is legal often comes from prosecutors, judges, and other lawmakers or detractors who wish to discourage its use. They will often strongly imply or outright falsely state, even in the instructions to the jury, that there is no such thing as valid jury nullification, or that to engage in jury nullification would constitute a violation of the juror's oath. Such harsh and seemingly authoritative statements are intended to dissuade jurors from exercising their full authority as the final arbiter in the courts of law. But even in appeals cases with rulings unfavorable to jury nullification, such as those allowing judges to fail to inform or to outright lie to jurors about jury nullification, courts agree that jury nullification is a power that jurors have, that they cannot be punished for exercising it, and that not guilty verdicts cannot be overturned, even if arrived at by way of conscientious acquittal. It's ironic, then, that proposals to require juries to be informed of their actual powers are characterized as radical. The truth is radical. There is nothing radical about recognizing the wisdom of our founding fathers and reestablishing those sound principles of justice which we have allowed through carelessness and neglect to slip away. The so-called fully informed jury is the bedrock of our republic. As a practical matter, fully informed juries would result in little or no change in the great majority of all jury decisions. But in the few cases where juries asserted themselves and to some degree judged the law itself, they would help both secure justice and maintain a free society. Over time, if juries consistently nullified certain statutes by refusing to convict defendants, juries would be sending a powerful message to the legislative branch. The sovereign, the people, would have spoken, making an unjust law unenforceable and dramatically demonstrating that the law should be amended or repealed. But why would a juror want to nullify? Jurors may wish to nullify for a number of reasons, including a belief that the law is unjust or unjustly applied, belief that the penalty for violating the law is too harsh, or belief that there are mitigating circumstances that would make strict enforcement of the law unjust in a particular case. But it might be hard to imagine generally why a juror would want to nullify. So let me give you a few examples. In 2013, a jury acquitted a California man who punched a priest even though the defendant admitted guilt on the stand. Normally, jurors tend to convict when a defendant admits being guilty of an offense with an actual victim. In this case, however, additional circumstances cast the offense in a different light. The defendant in the case explained in the court that he had been a victim of molestation as a child by the priest he had punched. He said he sought the priest out with the intention of getting him to sign a confession of what he had done, but that things became heated when he felt that the priest was leering at him the way he had done to him as a child. The defendant testified that the long-term repercussions of the sexual abuse he had suffered included alcoholism, divorce, and 2 suicide attempts. He also openly expressed his regret for his actions to the jury. Because of the unusual circumstances, the jury in this case declined to convict him of felony assault and elder abuse and deadlocked 8-4 on misdemeanor assault. Jurors told the San Francisco Chronicle that none of the members wanted to convict the defendant after hearing his testimony about the alleged abuse at the hands of the priest. The jurors asked to remain anonymous. So that's one example. Let's talk about one more. And we talked earlier briefly about the Fugitive Slave Act and the Navigation Act. Earlier on in the show, we also talked about the marijuana case. But I want to give you another example, a hypothetical example that could act someday as a vital defense against oppressive laws, criminalizing behavior that is not really a crime. For example, what if Congress voted to ban gun ownership? Most of my fellow Hoosiers here in Indiana would instantly become lawbreakers, yet none would be viewed by their neighbors as having committed any crime. If an Indiana jury were informed of their true powers, it would be nearly impossible to convict a Hoosier who was simply exercising their right to keep and bear arms. But this kind of check on abusive governmental power requires that juries be well informed. Of course, juries could refuse, and occasionally have refused, to enforce just laws, but such cases are likely to be rare since most people agree on the government's basic duty to protect life, liberty, and property. Once informed juries started cleansing the system of unpopular and repressive laws, two changes would begin to take place among the people themselves. First, people's respect for law itself, something that has declined in recent years, largely because of problems or mischief caused by so much bad law, would be regenerated. Second, people's moral senses would be sharpened by their increased individual responsibility to preserve our freedoms. We would become, once again, a vigilant people, more keenly aware of the abuse of government power, jealous of our liberties, sensitive to the moral and philosophical prerequisites of freedom. America's founders did not place their trust in a professional judiciary controlled by lawyers, judges, and organized interests that make their living from government. They had a deep and abiding faith in the people themselves and placed the ultimate power of the courtroom in the citizens' hands. Isn't it time that we returned to this fundamental principle of our republic? Thank you for tuning in, and I hope you enjoyed the show. I drew from quite a few great resources to put this show together, but I want to point out two in particular. First is an article by Roger Koopman at fee.org, and the other is the Fully Informed Jury Association website. I have linked to these resources and a few others in the show notes. And as always, if you like the show, don't forget to give it a thumbs up and subscribe to help us spread the message of freedom. I look forward to talking with you again next week when we will discuss a firearms and self-defense related topic. What is castle doctrine? Until then, remember, you are the forge of freedom.